This is Michael Cowen, and welcome to Trial Lawyer Nation.
You need to show people the worst possible harm that negligence could have caused, because that's what the case is about.
What I'm asking you to do is to focus on what you can control, because that's where the power lies.
The Dalai Lama has a saying that in the face of anger, justice evaporates.
If you can't focus group it, you have to be very, very critical of your process.
The facts aren't good, you can't create a miracle.
We can agree to disagree and be zealous advocates for our clients.
Quit worrying about looking perfect. You're not going to. That'll come in time, but you can still be an effective litigator.
Welcome to the award-winning podcast, Trial Lawyer Nation, your source to win bigger verdicts, get more cases, and manage your law firm. And now, here's your host, noteworthy author, sought-after speaker, and renowned trial lawyer, Michael Cowen.
Today on Trial Lawyer Nation, I'm back in the studio with my partner, Malorie Peacock.
Hey there.
On our last episode, we were talking about trial prep because we were getting ready for a trial. Now we've tried the case, and we wanted to share a little bit with you about what we learned in this trial and kind of the difference between the planning and then the reality once you get into the courtroom.
Yeah, I think that's true with every trial. What you plan is not always what ends up happening in the courtroom, but I think a lot of the things that we did plan for happened perfectly. So I think it'll be interesting for the viewers to learn what happened. Viewers.
Spoiler alert, I'm just going to go ahead and start at the end. We did end up winning the trial, I'm happy to say. It would be really embarrassing to have done a whole episode and share it with the world about how we were prepping for a trial and then get a goose egg, but it will happen sooner or later. But luckily it didn't happen this time. So the jury did find the defendant negligent and awarded $3,420,000 in damages. Not as much as what I wanted, but it's still a lot more than the client could have settled for. So we're happy with it. I think the trial went fairly well, but a little bit of background on the case too. Mallory, you want to give some of that?
Sure. So this was a construction site accident case. And so it's a little different than what we usually do. We do a lot of trucking, but we also do workplace injury here. And so in this case, our client was working on a utility pipeline construction project where they had to dig trenches, install new utility lines. The company that he was working for was digging out the trenches. OSHA has a lot of rules and regulations about what you need to do to protect workers inside of trenches. This company does none of them. Sends our client into the trench. Predictably, the trench collapses on top of him, and the force of the dirt of the trench pushes him into the pipe that he was working on and kills him.
And OSHA did find that the company did not provide the required trench protection, although we had all kinds of evidentiary fights about how much of that we could not get into evidence and what we could say about that, because the jury has to make their own independent decision. They're not bound by the OSHA, and the OSHA investigation settled also. It was not a final trial, so that was interesting. And for those of you outside of Texas, in Texas we have optional workers' comp, and this company did not have workers' compensation in place at the time. They claimed that they should have, and they actually have their another lawsuit against an insurance agent that's going to happen later, but they did not have workers' comp coverage. So we actually directly sued the employer, which is different than most of these cases where you're going after a general contractor or a third party. So let's talk about some of the challenges. Let's just start, first of all, with some of the logistical challenges, because we were set for trial on a Tuesday, and we were supposed to be the only case set for trial that Tuesday. Is the Tuesday of Martin Luther King Day week, and we were guaranteed we were going to go. We had all our experts ready. We had our hotels reserved. We had a U-Haul reserved to haul down all of our trial exhibits and posters and stuff. What happens?
Yeah, so we got a call from the court saying that it just wasn't going to happen. I mean, it's just, there was issues with whether or not we could get a jury panel. There were issues with the court schedule. There were just all kinds of issues. So they decided to bump us to the next week, which kind of set us into panic mode a little bit, because we had planned everything for the week we were supposed to go. And they just moved us up 1 week. So we had almost no time to sort of recoup and gather everybody again, make sure the experts were available, make sure we were available, all that kind of stuff.
In fact, we were driving into town. We had, it's about a 4-hour drive from San Antonio, where we live, to Edinburgh, Texas, where the trial was going to be. And we were almost to town to go meet with our clients for additional trial prep when we got the call that it was going to be yet another week.
Right. Luckily, while it was a big kind of deflation for us, we had all our energy going. We were worked up. We were ready for the trial. Luckily they only pushed it a week, so we didn't have to redo a lot of work or anything like that. And our expert was fortunately available. So it all ended up working out just fine to have it the next week. But, you just have to kind of roll with the punches.
And I think that's the lesson learned, I think, from that, is you just have things happen that are totally outside your control. You getting mad is just wasting energy. And so you just have to accept life for what it is. If the expert wasn't available, we either would have done a trial deposition because defense counsel couldn't claim unavailability. They were supposed to be there ready for trial, or we would have had to just beg for another date, which we didn't want to do. So that's I guess the first lesson there.
Right. And I think, with the case itself, there were a lot of challenges. It sounds like a cut and dry case. Someone gets sent into a trench with no trench protection. The trench collapses and kills them. That sounds like an easy win, right? What were some of the challenges that we faced in the case itself?
Well, I think one of the biggest challenges we had is we had to try a case with no eyewitnesses. And what I mean by that is, of course, our client, our decedent, is dead. The foreman, actually, for the company had died of unrelated causes in the interim before he could be deposed. There were 2 employees that we identified, and our investigator went and spoke to them, and it sounded like they were going to say great things. We subpoenaed them for depo. They refused to show up. So we're left with the choice. We can have them arrested, but I doubt that their testimony would remain favorable. And so what we had really good employee statements that were given to the police department when they investigated. And then there were statements given to OSHA, although OSHA doesn't give you the individual witness statements because they want to protect the anonymity of what employee said what. We kind of had the summary, and then OSHA did, at least summarize what the foreman and what the owner of the company told OSHA. But it did present a challenge to try to cry the case on witness statements. Luckily, they're all admissible statements of a party opponent. But I think one of the consequences of that is there was a fight as to whether or not a certain document the defense had. They claimed it was something that they created 6 months after the incident, where they claimed that our guy was actually instructed to work in a shallow part of the trench, and he chose to jump into the deep part, and it was his sole choice of breaking instructions and not following his training that caused the trench collapse and his death, which was pure hearsay, I thought. But I
thought so too.
I think when they were claiming it was a business record, I think that because we got in all our statements, I think the judge wanted to even it out and give them a fair fight. And I think that ended up getting in because of that.
Yeah. So that was a challenge for liability, that there were no eyewitnesses that could come and testify. But we also had some challenges, I think, in the damages area.
But I want to go back to liability more.
Okay.
One thing I found, and you're looking at the case, and we read the witness statements, and they seem solid because we read the OSHA conclusions. They go with OSHA conclusions. We're fine. When you're actually trying the case, they're usually written by the police officer. They're written by somebody. In this case, they wrote them in Spanish. They had to get translated. They're not really super detailed.
Yes.
And, I think they all left enough ambiguity. Like they said, we were digging in the trench. Well, they didn't say specifically what part of the trench they were digging in. And we could tell from OSHA's conclusions, at least OSHA, after talking to them, concluded that they were in the deep part of the trench. But we didn't put, we were in the part of the trench that was 9 feet deep, or just nobody had thought about these arguments at the time. And so we couldn't ask the kind of follow-up questions you would ask with a witness. It made it more difficult.
Right. And for a little background for people listening that don't know anything about trenches, which I did not know until we worked on this case,
Me neither.
there are some rules that OSHA has about what kind of protection you need in trenches that are more than 5 feet deep and trenches that are less than 5 feet deep. And the problem with this particular trench is that it was angled at a slope. So there was a portion of the trench that was 9 feet deep, and there was a portion of the trench that was like 4 feet deep. And there was a question about where were people working, where were they instructed to work? And it makes a difference for our case for what kind of trench protection would actually be required.
And whether they were negligent or not.
Right. And whether they were negligent in what they did provide. So that was a key component of the case it was difficult for us to have follow-up questions about just because of that.
Yeah, it worked out, but it was harder than I thought it was going to be when we were first planning the trial. And it wasn't really until, the week before when we're getting ready to try the case that I really realized, like, man, I really wish I had someone to ask follow-up questions.
Yeah, I think also the power of the testimony or the statements even, or the evidence is lost when you don't have a live witness. So we had to get all of these statements in through our expert witness, right? So somehow we had to present them to the jury in a way that was useful.
Yeah.
And so that's the solution that we came up with, is that we would present them through our expert. But because there were no follow-up questions, a lot of it was lost, and it gave fodder for cross-examination because there aren't details in there. So the cross-examination is, well, what about these details?
Yeah.
And the expert would have to say, well, I don't know. This is what I have,
Yeah.
So they lost a lot of power that we would have otherwise had with a live witness.
We were also able to use them when we cross-examined the owner of the company, because he wasn't there that day, but he came in and still gave their story saying, well, based on our investigation, this is what happened and this is why it was all right. So we were able to put them up on a screen and use them to read and cross-examine, but it's still not as powerful as having a real witness there.
Right. Right. And there's just questions unanswered. I mean, we had questions that were unanswered about the case. So I would imagine the jury did too.
Yeah.
Which makes all of your evidence less powerful. And it just gives more for the jury to talk about back in the jury room and wonder about and question about. And ultimately, I think it brings your damage award down a little bit. If the live witnesses had been there, maybe it would have been higher because they would have been sure of what we were saying.
Yeah, I think that's very possible. And it also meant that, at first on this case, I thought it was such a slam dunk. I didn't really have to work on preponderance as a standard. And then, we used the Keith Mitnick's doubt is not an out to talk about preponderance. But I really did have to talk about the burden of proof because they were going to be able to raise some doubts just because of the fact that, the statements weren't written to answer all of our questions. The statements were just what a witness told the police that day. And so we needed that.
Right.
And thank you, Mr. Mitnick. I've used that many times, and it works.
It works. It's so powerful because it's always the defense is, what about this and what about that? And throw anything at the wall that sticks. I mean, in every case I've ever tried, that's been part of the defense's strategy. But we don't have to prove things beyond a reasonable doubt. Yeah. And so we just have to keep reminding the jury of that. And the best thing is doubt is not, it's just so powerful and it's so memorable for jurors.
Reminds me of Johnny Cochran. So I want to talk about, we had some challenges on damages as well.
Yeah. So, it was a huge combination of factors in this case that gave us challenges for damages. The first was that our client was working under someone else's name with a social security number that was not his because he wasn't documented.
And usually, because I know if we don't explain this, we're going to get some comments about that should never come in. Right. Why did you let that in? And we would normally, and we briefed it up, exclude this evidence because the law in Texas and most states actually is that evidence of legal status is not admissible.
Right.
But in this case, because we only had witness statements, and half the witness statements called him by one name and half called him by another, and then they explained in the police report that there was a different name, we could not find a way to prove our case without it.
Right. And so it goes back to only being able to try it through the witness statements instead of the actual witnesses. We had to make a choice. Do we get these statements in, and does the jury make sense of them? In some kind of way, or do we keep out the status? Our other issue was that we were afraid that it would come out some other way. And if we didn't address it, the elephant in the room, then it makes it a bigger deal.
Yeah, there's a second argument that the defense had for admitting our client's immigration status, and it's one that actually really pisses me off. And I like the defense lawyers; they're friends of mine. But they did a good job defending their client, and they made whatever arguments they could to win. But this argument just really, really got under my skin, because I really love our client and believe that she's a legitimate and sincere person. But they'd only been married for 9 days
at the time that he died.
At the time that he died, there was she thought they were common law married before that, but they had their wedding ceremony 9 days before he died, and they didn't have a lot of pictures. They just weren't. It's an old case. We took over this case from another lawyer. Long story, but it was 10 years between the time of the death and the time that we got to try the case. We'd been on for 2 years trying to get to trial the whole time. We finally got to go 2 years later. But back at the time, they didn't own phones that had cameras. And so there aren't pictures a lot. They just have very, very few. And they made the argument that the jury could consider whether this was a real marriage or this was a sham marriage to get him papers. And another thing is, our lady was a bigger lady. And I think, and she was a couple years older than him. And I think they were kind of implying or hoping the jury would think, well, why would a guy like a lady that's, obese and older than him, that this had to all just be a sham to get papers? And unfortunately, we were convinced that there was enough of a risk that the judge was going to let in the immigration status or exclude our witness statements, which would have been just as bad, because then we would have lost on liability, that if we didn't address it in voir dire, that it would be a problem.
Yeah, and I think there's a lot of attorneys that forget, and I've heard a lot of attorneys say this, a limine motion is not a motion to exclude it for the duration of the trial. It's a motion to approach the bench before you talk about it, that someone has to open a door or there has to be a reason later on in the trial. And the problem is that means that the judge can always change their mind based on the way that the trial goes. And whenever you have any kind of limine motion, that's always the risk. So you have to weigh that, with the odds of it coming in, because what you don't want to do is not address it, not talk about it, and then it comes in during the defense's case in chief and there's nothing you can do about it.
And we did find out in jury selection that at least there are some jurors that absolutely came forth and said, they said, wait a minute, this is the case where someone's undocumented, working under someone else's name, and they're suing after they got killed. They're found suing after they got killed. I'm like, I can't do that. That just offends me so much. That's what some of the jurors said, not me.
Right.
That they just could not even consider finding anyone negligent or awarding allowing any damages. So if we hadn't voir dire on it, that could have been very bad.
Right. We could have got some people on the jury that would have, just totally tanked the case.
But so that was a challenge. That was a real challenge. We also had no real, our guy was a very low wage earner, so we didn't want to even try to put in economic damages. We also didn't have, tax returns. Any tax return that would have been filed would have been under someone else's name. We wouldn't have a right to go get them. Right.
We just didn't really have a good way to prove what the lost earnings were.
And we didn't want to, because it would have anchored it to a low number.
Right. It wouldn't have been that much.
In fact, the defense actually brought up how much he made and said, if you find negligence, then, $9 an hour, which is what he made, would be a good measure for her loss.
Right. And it was a low number. I think we calculated it out, and it would have been, I think, like $600,000 or something like that. So over the course of his lifetime. So that was not a good anchor for us.
Yeah.
And I guess the jury didn't use that had a method to calculate. It's always hard to know what method they used, but
yeah. They did ask for a calculator, so they used something. But
yeah, they did ask for a calculator. So that's something that was interesting. We got during the jury deliberations, and I actually don't know if this happens in every state or how it works, but in Texas, the jurors will write a question to the judge, and the judge will present the question to the lawyers, and then the judge decides how to answer it with input from the lawyers if the judge asks for it. Most of the time, the answer to most questions is you have all the information you need. Please go back and keep deliberating. But we got some interesting questions in this case, or some interesting notes. So the first note, I thought, it was maybe 30 minutes after they started deliberating, and we got a note already, which always your heart skips a beat a little bit. You're like, oh my gosh, do they have a verdict already? What's going on? A fast verdict is usually not a good verdict for a plaintiff. And anyway, so we got the note, and it was that the court reporter forgot to give the exhibits to the jury. They were asking for the exhibits. So that one was, nothing. The second note that we got was about common law marriage. So this was an interesting challenge for everybody. How do you answer this?
Yeah, because it was not part of the case. They were legally married. There's no question about it. But in deposition, our client had contended that she was common law married from the day that he moved in with her, which is about a year and 2 months before he was killed. And we didn't even bring it up, I don't think, in direct, because it wasn't relevant. The fact that they loved each other, they lived together for a year and 2 months, they had gotten married, they were married. We're talking about the lost future. But the defense lawyer brought it up
during the cross-examination.
During the cross-examination to try to attack her credibility, and then also brought up stuff like, well, you were receiving, which normally wouldn't come in, but we had realized a judge who I really like by the end of the trial. I don't want to sound like I'm criticizing, but we had a judge whose inclination is just to let it all come in and let the jury sort it out.
Right. And a lot of judges, I think, are like that because it's less likely to be overturned if the jury hears everything versus if there's something left out that was critical.
Well,
I don't know. Maybe
some of this, if we had objected enough, we may have created reversible error if we wanted to appeal it, but I'm not going to appeal a multi-million-dollar verdict in this case. But one of the things, so he brought out, well, you were on food stamps. Did you tell him when you got caught common law married that you now had another wage earner and you weren't eligible for food stamps anymore and stuff like that? And then, let him get into some stuff that, wasn't as pretty. It really kind of gummed up the works. And what do you do at that point?
Right. And so then the jury came back with a question about what is legally required to be common law married or something to that effect.
And they thought there was a time period.
Right.
Which is not in Texas law. There is no time period.
Yeah. It's a misconception that I think almost everybody has. I always hear people tell me you have to be married for 6 months. I don't know where people get this from, but that's what everybody thinks.
Right. And I wanted to instruct the jury that if they're asking the question, why don't we just tell them the truth? You have to agree to be married, live together as man and wife, and hold yourself out to other people as man and wife. There's no time limit. And the judge said, no, I think we finally got a note saying that's not an issue for you to decide in the case or something.
Right. Because ultimately we were debating whether it would be, if we send the regular note back, which is you have all the information that you need to decide this case, please decide it. I think we were saying it would improperly mislead the jury that they need to make a decision about common law marriage in this case, which they did not because they were legally married.
And we were aware and of course we can't talk to them. They're in that other room. That maybe they were confused thinking that was something we had to prove in order to recover in the case, which is we had a marriage certificate. They were legally married.
Right.
In fact, at that point, I was like, maybe we should introduce the marriage certificate. I thought since it wasn't controverted, we didn't need to put their certificate in evidence.
Right.
And I thought I had addressed it in my closing too. I don't remember, but
we had addressed it. It was something, and this is the case. If you've ever watched a focus group deliberate, they go off on these weird tangents, and this one person just can't get something out of their head, and so then they're all just talking about it for hours sometimes about some non-issue in the case, and then they all move on from it and never talk about it again and proceed accordingly.
And they came around, and I heard this secondhand because I've not spoken to the jurors, but I had lunch with the defense lawyer, and he spoke to the jurors, and he said that evidently there were a couple that were against us, and what brought it around was the foreman said, "Look, we all took an oath. We have to follow these instructions. We have to base it on the evidence in the case," and that brought them around to doing the right thing. But there were 3 jurors that just didn't particularly like our lady and wanted to give her money. And I think part of it is just the prejudicial stuff that came in kind of spilled over and just falsely made her appear to be, in their eyes, not worthy.
Right.
And it's a problem when you're representing people, especially in this political environment.
Yeah.
You're representing people that aren't educated. You're representing people that She actually was legally a U.S. citizen, but
Right.
you're dealing with issues with undocumented status. I mean, it brings out some ugliness in some people that we just have to know is there, and it's a bit of a wild card when we try cases, which is why we normally would keep it out. But in this case, there's no way it was going to stay out.
There was no way.
And for those of you listening, said, yes, I would have kept it out. I would have found a way. The judge was not going to let us redact and type in a different name in the reports.
Right.
We thought about it. We talked about it, but it wasn't going to happen. So, it's better to have a jury maybe hear the bad stuff and not give you as much money than to not hear the evidence of liability and give you no money.
Right. And it was a really tough decision that we really, really went back and forth on. And we, like Michael said, we briefed it and made kind of a game time decision of what we were going to do the night before. We had all the briefing ready to go. I mean, we know what the law is. We decided on a cost benefit analysis that this was the best way to do it. And ultimately, it worked out. I mean,
but when you're in trial, you have to do you just have to go. Sometimes, you just have to go with your gut, make the best decision you can make, and try the case. And then, I wish we had perfect answers because I know our clients only get one shot, but that's what you can do. Well,
and sometimes what's legally allowed or what you could do is not necessarily the best strategy for the case. Right. So just because you can do something doesn't mean you necessarily should in every case. And that's what makes this an art and not a science.
Exactly.
Each year, the law firm of Cowen, Rodriguez, Peacock pays millions of dollars in co-counsel fees to attorneys nationwide on trucking and company vehicle cases. If you have a case involving death or catastrophic injuries and would like to partner with our firm, please contact us. We have experience finding potential defendants that other firms miss, and we've added millions of dollars to cases by finding these sources of recovery. If you have a catastrophic injury or death case where the policy limits appear to be insufficient, give us a call. If we can find another defendant, we can partner on the case. And if we can't, then we won't ask for any of the fees. You can reach Delisi Friday by calling 210-941-1301 or send an email to podcast@triallawyernation.com. She will coordinate a time for Michael Cowen to speak with you in person or by phone to discuss the case in detail. And now, back to the show.
So we had the pre-trial, the Monday we just did a pre-trial in the afternoon and did jury selection the following Tuesday. So we had a juror panel that was told to come on Monday, sat around all day Monday, and then went in Tuesday morning finally to actually get to be on a panel. I don't know if some of them would have been on a panel the day before and not selected or not. Yeah, but they were already, and sorry that Lamont talks about from hostage to hero. You want to talk about hostages. The second day of having wasted your whole first day, a lot of people were not thrilled to be there.
Yep, it was a low energy group, I will say. They not thrilled to be there. And, frankly, and Sari is right about this in her book, that they don't understand what's going on or what's even coming next. They don't know if they're going to have to keep doing this over and over and over for days. No one tells them any of this information. Lawyers know, but they literally have no idea. They don't even know when lunch is, like she says. Yeah. So that it's stressful to be in a situation where you really, really don't know what's going on. And I think that you handled this really well in Fort Ire. You gave them the basics right up front. Like, this is what we're doing. This is our plan. These are our goals. Hopefully we can get you out of here quickly.
And I can't really take credit for it because what I did is I took what I've learned. I decided to try a Sari de Lamont Fort Ire. Mm-hmm. I've tried different methods. I like a more inclusive Fort Ire. Whether I'm right or wrong scientifically, I can't tell you. But it's what I've been doing lately, and it seems to work more often than not. I can't tell you what the result would have been had we done it differently, but I liked it. I followed her method, which is, first of all, you tell them what we're doing, why we're here. And, you create that design alliance, like, I want to try to give you a choice. And then, I think I felt pretty good about doing her thing where we bring up, this is a case about, something happened in the workplace. Anyone here have safety rules in the workplace? And the great thing we did is that so many people had jobs, and the jobs is frightening, even like teachers and that where OSHA rules applied and people liked them.
Yeah. Well, and there was a kid on our jury. I say a kid because I think he was maybe 18 or 19. So it's probably his very first ability to be a juror. He gets called, right? He actually ended up on our jury, and he knew about OSHA rules from his theater program in high school. Apparently they had to follow some kind of OSHA rules when they were building sets and stuff like that. So, it was just amazing how almost everybody was familiar with them.
Right. And and I felt really, really good about it. One thing, because I talked to Sari, I work with Sari as a coach. And so I was talking to her about my voir dire, and one thing she said is just don't start off with like I would have done before I worked with Sari. I was like, one of the things I'm afraid of in this case is my client's undocumented, because you'll get a lot of pushback. But we started talking about, this case involves a death. What do you think? Is it okay to sue for death? Well, you do it for devil's advocate. Well, no one's going to bring it back. And I can't remember. I think it was under the workplace safety rules where I brought out. I didn't want to do under the money part. Right. What if the person who got killed is undocumented? Does that make any difference? And we had 2 Border Patrol agents on our panel. Yes. Which, if you're going just by demographics, would scare you. And they were both super strong on it doesn't matter whether you're documented or not. You still have the same right to the workplace safety. And right. We got to do a little talking with them about how, they get criticized a lot, but actually the heroic efforts where they're like going out and now they're arresting them afterwards, but they are going out and rescuing people and putting their own lives in danger sometimes. That when people get stuck in bad places when they're trying to cross, either in the water or out in the desert somewhere or something. And, I honestly think neither one made it on the panel, but I actually think either one of them would have been fine for us on that issue. Shockingly enough. Yeah, I thought so too. The things that they said and their thoughts about the value of human life were really touching. Both of them had touching stories about it. They didn't end up on the jury, but yeah. One thing that did disappoint me is at the end, I asked, well, who would like to be on the jury? And less than half the people raised their hand. I was hoping for more than that. And I think what happened is, I'm learning a new skill set from Sari. Mm-hmm. And so in the getting them, I was already good at getting people talking, but the going back and forth between being authoritative and then being questioned and learning how to do that, I think I did a good job with that. What I did not do a good job at all was creating a group. I didn't get them talking to each other. I just forgot. I was so wrapped up in I guess the new things I was learning, I forgot to get them to talk to each other and create a group. And I think that is partly why I didn't have so many people want to be there, because they didn't feel like they're part of a group yet. So I had the exact opposite reaction that you did. And I told you this at the time of the jury selection. I was actually shocked that so many people wanted to be on the jury. In my mind, people don't want to be on a jury. So I was shocked anybody raised their hand. And it was a significant number of people that said that they actually wanted to be on the jury after jury selection because they were interested and they thought it was something that, they could be a fair, because you said, I only want people that can be fair. And these people raised their hand and said, I'm interested. And I think I would be a good juror for this case, which I was just shocked that so many people raised their hand. We did have some good people too. And I liked the jury we ended up with. And even some people that didn't want to be there, like we had 2 poor alternates. They sat there through the whole trial and then they got let go when deliberations started and we got to talk to them. And, they were very happy to have been part of the process. They wanted to know what happened. One of them actually friended me on LinkedIn afterwards, and wanted. Like I said, it was really. So by the time they went through the process, they were glad they did. But at the beginning, I have such high standards for myself. It's like, we got a multi-million-dollar award, but it wasn't 8 figures. A lot of the jurors want to be on there, but they didn't all just fall in love with me and want to be part of my group and stuff. And, it's just, you're always striving for perfection. It's not that I'm going to beat myself up over it, but you always want to do better. And so I know that, one of the things I'm going to work on next time with Sari and the next time for my trial when we're doing our practice stuff is the group formation part of voir dire, getting people to talk to each other more, because I think that's kind of my next step on my path to mastery. Yeah. I mean, I think that whenever you're learning a new skill, you have to put it together piece by piece. You can't just jump in and be perfect immediately at it. I thought you did a great job. And like I said, I was shocked by how many people actually wanted to be on I had the opposite reaction. So I was excited about that. I mean, just generally. So what was interesting about voir dire,
is that when you do an inclusive voir dire, I've noticed this because I've seen you do it a few times. I've done it before. When you do an inclusive voir dire, it sort of sometimes it can force the hand of the defense attorney, because many attorneys do exclusionary voir dires. When you don't do an exclusionary voir dire, the defense attorney has a lot more questions that they need to get out than they normally would. Usually they can be the buddy that comes in and is nice or, whatever. But when you do an inclusive voir dire, it kind of puts some of the defense attorneys kind of outside of their wheelhouse a little bit and kind of forces them to be reactive instead of proactive, I guess.
The other thing is when you really get to listening to people and communicating with people and letting them talk and respecting them, a lot of defense lawyers don't want to hear it and they shut them down. So a lot of times we get that contrast. This particular lawyer on their side actually was a very gifted people person.
Right.
And he actually does plaintiff's work as well. And he did not have that problem. But we've often had that benefit when we've done the inclusive voir dire, but with this particular lawyer, it was good. I mean,
I think he did a good job. He had people talking.
Yeah.
And we learned, you can't stop learning from the veneer panel as soon as the plaintiff side sits down. You can learn so much from the defense's voir dire too about who you want and why you want them, and getting strikes out of those too. I think some of our cause strikes actually came out of the defense's.
Yeah, absolutely.
Questions rather than ours. So, we didn't strike a lot of people for cause in this case, but that wasn't our goal.
Right.
I don't know if that's right or wrong, but that's sort of the way it shook out in the end. I think we only struck 2 or 3 people for cause, maybe.
Yeah, they think there's some more, but they're further up. They weren't going to be reached.
That we didn't end up talking about. We didn't need to talk about them because we just weren't going to get that far. But that wasn't our goal. So
yeah, it's a little scary, but like I said, it's the couple times we've done it, it's worked out, and people have self-identified when we're trying to find out who's on our team that they're not on our team.
Yeah.
And again, I think we've discussed this before. I'm not sure the times when I've gotten a bunch of people off for cause, I'm really getting people that don't like our case, or if I'm just, okay, I don't want to be here. I'm learning the game. I'm going to say, answer the question this way. But so many judges now just come and, will you follow, I think this judge was all right. I don't think he would have done, but so many of them just, will you follow my instructions? Will you follow the law? Are you telling me you can't, are you telling me you're going to break the law and disregard what I tell you? The standard from some judges is so hard to get a cause strike. Now, I know people will, again, they'll disagree. Well, no, but you're not doing it. Well, yes, I have done it right. And if the judge follows the law, they send them off for cause. But I know judges that just feel it's their job to rehabilitate every juror, and they raise the standard higher than they should have been. And yes, I can go appeal it and maybe win, but I'd rather just win.
We had our pre-trial Monday. We had voir dire in the morning and on Tuesday. And then there was a big question about whether we should do opening statement, whether we should start evidence, what we should do next. And why was there a big conversation about that, I guess?
I forgot.
So there was a timing issue, but also I think all of us felt like we didn't want to do opening statements and then not present any evidence. And I think the defense agreed too. And the big thing about that is your opening statement is a preview of evidence. And if you don't start with the evidence right away, people aren't going to remember what you said.
Yeah.
I mean, especially after a really long day, people are not primed to listen to you anymore. and they're already mad that they ended up on the jury. Some of them wanted to be there. So,
the opening, I didn't feel any hostility in the opening. I felt like I had good eye contact, good body language, talking to the jurors. I don't know if you noticed anything different.
No, I thought it went well. One of the things that we decided for the opening is we had made a bunch of visuals for this trial. I think we were about 100 big boards that we made for the trial. And some of them were supposed to be for opening. And we decided that we didn't want to use any visuals in opening. Why did we decide that?
Yeah, and in fact, at first we were excited to use the visuals because we worked a lot with Rodney Jew, and he's really into visuals, and he sort of this method. One, honestly, it was a logistics thing that the Rodney Jew method, to do it properly, it calls for four tripods, and you set up, boards being up at the same time, they play off each other. And this courtroom was not one where we could set up, it just wasn't enough room.
Right, it was a small
tight space. But the other is, I was working with Sari Delamont again, preparing my opening. And I already decided I didn't want to use like 50 boards, but she says, if you tell the jury it's a simple case and then you use 50 boards to prove it, that your actions and your words aren't, 50 boards is not simple. So we decided not to, and she convinced me that me being able to draw things on a flip chart showed more authority, and that I do well in teacher mode and I'm credible when I'm in teacher mode, and that is something that would be better than using all those boards at that point. Not that we didn't use a lot of them later.
We did.
And because nothing else I think spectacular in the opening either. I'm not happy with my opening, but like I said, I did a combination Sari / David Ball with a slight modification that on the first few lines because neither one felt right. And Sari agreed with us. And, these are guidelines, not set in stone rules. And but I felt good with the opening. Then our first witness was our expert, and then we did use a bunch of boards.
Right.
Why?
So, like the jurors, I knew nothing about trenching operations or anything like that before we started working on this case. And, I'm sure all the lawyers know out there and have experienced this. When you have a case, you have to learn basically everything about what you're going to present to the jury. You need to be a master of the information. But then once you're a master of the information, you've mastered it so well that sometimes it's hard to put it back into regular terms and regular words for people who've never heard this information before to understand. So the purpose of the boards is to make your expert speak English and slow down and give authority to everything that they say. A lot of experts want to say, well, based on my training, education, experience, this is why this is the way they should do it, or this is why this is negligence, or whatever you're trying to get out of them. But jurors don't just believe an expert because they say that they're an expert. On the contrary, I think jurors have trouble with believing people who are paid money to talk. Yeah.
And as they should. And so one thing is everything our expert said had authority behind it. And we learned this from Rodney Jew and Amy Gallagher Hall, that on the lower right-hand corner. And so they started, we point out and then they start seeing it. We put where it came from. So we'd have a picture of the publication or document that it comes from. We'd have the quote that we wanted, our spin on it. And then we'd have where it came from for every little bitty piece of information. And it forces the expert to do piece by piece so the jury has time to do it. If they're wandering off from listening to him, they can read it themselves, but also shows them that, hey, we're not just saying this. This is a legitimate authority, which the other side didn't have.
Right. And so we did it for all the regulations that we wanted to talk about, because there's a lot of regulations in trenching operations. Regulations, they read weird. They're weird. They're hard to understand. And especially if you don't know anything about trenches, when you read them, it just sort of goes over your head. And so really breaking them down and giving the jury space to read them themselves, hear the expert explain what they are, go back and read it. It took forever. It took a long time to get through some really basic information, but having that basic foundation of knowledge, I think, really helped us build our case the way that we wanted.
And I think the first thing, we had to talk about is, what is OSHA? Why do we have OSHA there? This because people were getting killed. You have to protect people. And then, and this is what we have rules, and these are mandatory rules. They have to be followed. They're not options. And bad things happen. People are injured or killed when they don't follow the rules. Then we had to go into what trenching was and why it was dangerous, and then again, have authority for that. And then, I don't want to have this big, long regulation. And so, and we didn't make this up. We got it from an OSHA poster. But we said you have to do the 3 S's. You have to either what's called sloping, which is where you have a gentle slope instead of a straight up and down wall of the trench. Shielding, which is using a trench box. Or shoring, which is having an engineer come out and design a system to keep the trench from collapsing. But you have to do one of those 3, and those are the only 3 things you can do. And so if you don't follow the 3 S's, then you endanger the lives of your... Actually, what we came up with, you're gambling with the lives of your employees if you don't follow the 3 S's. If you do, then you're protecting them from being killed by cave-ins. And, I think that simplifying it made it so much easier. And, you can remember the 3 S's really easy.
I will say that for people listening, this strategy isn't something that you can come up with the night before and it will work. We actually worked on this I've been working on it for over a year, the visual aspect of it. We worked for days with our expert to come up with a plan for what order we're presenting things in so that it made sense, and we're building the blocks, we're building the tower of evidence, but how the expert should present it, where to stand, where to point, how to talk about it. All of those things have to be practiced, and it's not something that comes naturally, especially to expert witnesses who aren't used to doing testimony that way.
And he wasn't comfortable with it. And I love him, but he's a soft-spoken, not particularly dynamic speaker, very credible person, I think, and very knowledgeable. But I think, we got this allowed him to get off the witness stand, be more teachery, and I don't think he would have presented as well had we not had all these visuals. But yeah, it was a lot and even after we printed up, we found things that we needed to change.
Yeah.
When we went through them. And the other thing we found is that, we had 100, and you think, I want to prove this one little point and this little, and then you find that some of your posters are repetitive.
Right.
And so some of them we'd already planned not using, and some of them I made a game time decision because I could tell that the majority already got it. And if I had used that next poster, that I was going to start losing them. And just by watching body language, eye contact with people as to whether or not they're getting it, I skipped some posters once we got in there.
Yeah. So that's what's the cool thing about the posters is the problem with like a PowerPoint is that it's harder to make those little decisions. Like you're skipping past stuff and then you're lost and you can't. Whereas the posters, you just look at it and you say, I'm not ready for this one. Go to the next one or whatever. And you're right in the jury's face. So you can see if they're getting it, if they're reading it, if they're on the same page, if you need to go back, if they're lost, you can go back, you can keep referring back to things easily. So that's kind of why we liked the printed posters in that scenario better than the PowerPoint. It's a little easier to go back and forth.
Yeah, we used the computer to present documents and photos. And I did do some PowerPoint for my closing. Right. And it made sense there. To present. But that was more because I was going through, some evidence, if they say this, look at the judge, I'm taking notes. So if they say X, look at exhibit, I put it up, exhibit 3 on page 5, it says this. In exhibit 8 on page 2, it says this. Write this down. So if they say this is how you argue back, that's where you can look. Because I knew that they were going to try to confuse them on a couple of issues that I knew we were right. But yeah, I'm glad we used the posters, but it took 2 sessions, multi-hour sessions with our expert to get him somewhat comfortable with doing that. And then it also, we also had to make sure we had them ordered, we had them in the right order so that we weren't digging for stuff at trial. So we had to put them someplace easy to reach in the right order. Stacks that weren't too big, but not too small. It was just practice. That's all I can tell you.
It was. It took a lot of practice. It's not something that just materializes overnight. The other really cool thing that happened with the boards, which I just loved because I made a lot of the boards, and so I really loved them. But is that if the jury wanted you to move out of the way so they could see the boards, so they could make sure they understood it, they would just ask in the middle of, they would say, I can't see that, or can you move a little bit over? And I thought that meant they were really connecting with the method. They were getting it. They were understanding why it was important, what they needed to look at, and they cared about looking at it. So,
and I felt they felt comfortable enough to, it doesn't happen in most trials, but actually speak up, say, I didn't get that. Can you hold it differently? Can you get out of the way so I can see better? Can you ask someone else to get out of the way so we can see better?
Right.
It was nice because you feel like you're building your team.
Yeah. So that was, I don't know if that had to do with boards or if it had to do with this jury panel or what it had to do. Who knows? But but I appreciated that the jury seemed to understand how we were using them and what they needed to get from that information. So after the expert, we did have some we had some videos that we had to present, some police officer testimony to prove up photos and information that they found and people that they interviewed and stuff like that. So,
and how deep the trench was when they got there.
Right. So we actually had a person in our office do the video edits and take out the really long pauses and stuff like that, which I actually think was great because each of our videos was only, I don't think any of them was over 15 minutes long.
No, they were all under 15 minutes.
Which was awesome. And that way we could play them quickly. We're not boring the jury. And we spaced them out so we weren't playing a bunch of videos back to back.
And we did damages first, and then kind of the forensic pathologist autopsy kind of bridge between liability and damages. And then you did all the damage witnesses.
Yeah. And to correct you, we did liability first, and then we did the forensic pathologist.
I thought that's what I said. Okay. We did liability first, and then we did the forensic pathologist as a bridge, because she asked her opinions as the mechanism of injury was consistent with our theory of the case on liability. But then she also talked about how he was killed, and it was gruesome, unfortunately, in this case. And then moved on into damages. And so you had to discover some stories in this case. So what did you do to find out what those stories were and how to tell them?
So I spent a lot of time with the client and her witnesses. So frankly, the only way you get it is by spending time and building trust and listening to stories and listening to, unfortunately, the same stories over and over until they feel comfortable to tell you the real stories, right? So every client, I think it was it Randy McGinn that said this, that clients tell you what they think that you want to hear, sometimes to get you to take the case, but they often tell you what they think will be helpful to the case, because they don't know anything about presenting cases. Right. And so to get the real stories, you just have to spend time and build that trust. So a lot of the stories we didn't get until the day before trial, even though I'd met with the clients and her witnesses multiple times, and at the house and everything. Everything. And the night before, we got some news stories that were great that we ended up using at trial. Yeah, and not that the news stories were like something different. It's just they were details that we didn't have before. Right. Far as things they've done together. And the thing is that the details are important. That it can't be. It's never effective to say, I'm sad because he died. They know that. They want to know how you're sad, or what are the things that you're missing out on. And it has to be stuff that people can connect to and that are specific. And spending time teaching your client how to tell stories and what makes a good story is something that you cannot skip. People don't know how to tell stories. And not just the client, but her daughter, her sister-in-law, her sister, everybody. Luckily, in this case, we had just a really great client and really great witnesses. But our client was sort of a natural storyteller. But we didn't realize that till the end, because she was so guarded. Right. And part of it is she had been kind of passed around. She did not, before our referring lawyer got the case, did not necessarily feel particularly. And it could have been her perception, because the lawyers she had before seemed to be the ones I know are nice people, but she did not feel very respected in the process. The continuances made her feel so. She was distrustful. She felt very disrespected. She had a lot of still grief and depression that wasn't fully treated. Yeah. And I think it took a while to break through to her. Now, one disadvantage, you did all the workup on this case. And so I literally, you and I talked about strategy. Yeah. But other than, I think I did the pathologist depot. Right. And I was going to do the coworker depots, and then they were too scared to show up and didn't show up for their depots. And so I didn't really meet the client until a few weeks before trial. And I didn't really get to know her until like a couple of days before. And I was still going through the emotional journey of the case during the trial, and I have mixed feelings about that. On one hand, I was really connected with her. On the other hand, I was probably, there's nothing wrong with showing emotion in trial, but I think I was overly emotional. I mean, I cried more than I wanted to in closing. Mm-hmm. I got mad and yelled once at the defendant. He deserved it. I mean, because I thought he had manufactured the report that they put in, and then we had discovery fights to compel documents, and all their training documents were dated after our date of our death. Right. There were no training documents they gave, and then on the witness stand goes, "Well, I'm sure I have them in the archive. I'll bring them back tomorrow." And I just lost it. Well, you're going to make them. You're going to go make them up like you made up the other document. Yeah. But I should not have yelled. That was unprofessional. It was real. It was real. I just snapped, but I think had I not been going through the journey, had I been able to process it far enough in advance before trial, I may have been a
a little more in control, a little less sobby during my closing, because I don't know if it was too much or not. I just don't know.
Well, and it's hard to know. We didn't. Who knows what the jury thought about it? I don't know what the jury thought about it. But I think that there is something to be said for making sure that you fully processed your case and your own emotions and your own connection to it before trial, because I think it made the trial harder for you. So I don't know that it was ineffective, but I think for you emotionally, it was a much rockier road through the trial. So I think it was more stressful for you. I just think it was harder for you to enjoy it. And I mean, it was just harder for you.
The liability part, I was having a blast.
Right.
But it was an emotional, the trial was emotionally rough on me.
Yeah.
I mean, that drive back, we get this multi-million-dollar verdict, and I'm just, it's a weird feeling. I felt good the next afternoon, but it just took me time to process. It was just we were dealing with so much pain.
Yeah. Yeah. And this is kind of a unique case. I mean, trying a really gruesome death case is different than trying a back injury case.
Yeah.
It just is. There's a different kind of an emotion attached to it, and different kind of emotions from your witnesses. And it's, I think, psychologically, it's always tougher to try this kind of case, just because it is. And so if you don't give yourself time to deal with that, then it can really take a toll on you.
Yeah. Luckily, we were doing, I actually exercised during the week. We did our protein shakes. I meditated every morning before trial, prayed every night. I did the things I needed to do to keep mentally and I think we were sharp the whole time of the trial. I never felt big energy drops. I didn't.
Yeah. Yeah. I think it went pretty smoothly. Overall, everything kind of went smoothly. I don't know how else to say it. The witnesses were available. We didn't have any weird, calls where people didn't show up or something like that. I mean, there was, when I did put on the damages witnesses, they went pretty smoothly. They told the stories that I expected them to tell. There wasn't any crazy, something that came out in the trial that was unexpected or anything like that, really, from them. That all worked out, I think.
Yeah. The one last thing I want to talk about, and it's something I'd heard about before, but I've never experienced it before.
Mm-hmm.
And we talked a lot about this, is the potential of a trial to heal.
Yeah. Yeah, that was something I'd never seen before.
Yeah.
So how did it play out in this case?
Oh, boy, I'm going to get emotional. So one of the biggest harms, I thought, is that we had a woman who felt that she was disrespected, that nobody cared about her, that no one cared about the death of her husband. The $20,000 fine that OSHA gave did not particularly change that on a $1.2 million construction project. And she just really, and it dragged on for a long time. And she had some probably pretty low self-worth. A lot of the love story we had is this is someone, like the first man in her life that actually made her feel like she was someone special. She was better than she thought she was. And, and she felt that when she lost the most important thing she had, that people didn't care. And that maybe she wasn't, maybe secretly deep down worthy of people caring. And to have a jury give a verdict and put, I think it was $2.5 million for her mental anguish. Very emotional for her. I'm hoping it's going to be very healing for her. I think it was very cathartic. It gave her a closure that she needed. It gave her a sense of the community saying that you matter, that he mattered. And whether we actually end up getting her the 3-point-something million plus interest, or whether he gets taken away someday, I think just that healing was worth all the work. Sorry, crack up.
Yeah. For her, and it was very real when the jury started reading their verdict and they started putting money in the blanks. She just started sort of sobbing uncontrollably. But it was sort of it wasn't a sadness, and it wasn't even a happiness. It was finally someone heard me. Finally someone's listened to me and they've believed me. Yeah. And they're showing me that they believe me. And it was very, very powerful. And
so I've had both experiences. I've had a death case where we've lost, and that is a very powerful hurt that I want to avoid inflicting on a client. In fact, there's cases that we're now not taking where we could settle for something okay, but it's a death, and we don't feel like something okay is enough to really make a difference in the person's life. And if it gets pushed to trial, more likely than not, that's going to happen. And, I'm not in an economic position where I need to take those cases. Someone else will take it, and that's fine, but I don't want to put someone through that. But also, I think there's some other cases I'm more likely to go to trial on now, because I think that jury verdict brought more closure than a settlement would have brought.
I think so too. I think I've seen this in every single death case that I've ever handled. The case itself is the last stage of closure.
Yes.
For people who've lost someone. And because the cases go on for so long, just because of the nature of the justice system, it's slow. It's hard for people to leave it, because it's sort of the last step of trying to move forward with your life. You never move on, but it's just moving forward, and you can be stuck in that place, and you have permission to be stuck because you have this case going on, but then no one gives you permission anymore after that. Yeah. And so even in settlements, you have very reasonable settlement for a death case. It's still very hard for people because it's sort of the last stage of letting go.
Yeah, absolutely.
And in this case, for her, my hope is that this can be the last stage of her letting go and trying to move forward, not move on, but move forward in her life.
And I had a big talk with her about that afterwards.
Yeah. Yeah.
People do care about you. You're a wonderful person that has worth. And, don't waste the rest of your life. You need to be there for you. You need to be there for your daughter. It's time to take this as something, acknowledgement that you are loved, you are worthy. Get off your ass and do something. I didn't say those words, but
right.
Because she was so down that she basically gave up on life and just would hardly even leave the house. I'm hoping that this, and I really do think it's going to happen. I really think that this verdict is going to inspire her, because she had a lot of self-realizations. Like, while I was so down myself, I wasn't there for my daughter. And I think the whole process was very psychologically healthy for her. I do truly believe that, irrespective of the money, I think this process and her community believing in her and validating her is going to help her in life.
Yeah, I think so too.
Well, I hope this is helpful. I know it's really fact specific to our case, but it's always interesting I always like hearing about trials, so I hope this was useful to y'all. If you have any other follow-up questions, feel free to send them to us or put them on our Trial Lawyer Nation's Insider Circle Facebook group. We will be doing another Facebook Live here in a few weeks. The date will be announced. I don't remember what it is, but Delisi, our marketing director, will sure announce it as part of the other stuff you hear on this episode. So if you have any other questions, ask, and I'll be glad to answer them.
By the way, Michael, before you do our closeout, I just want to say that some of the people who tuned into the Facebook Live got a really interesting treat because it happened to be, if you don't know, it happened to be while we were picking a jury. So we, because of the change in the schedule and all that, we didn't want to move the Facebook Live. And so Michael finished picking a jury, and then the judge was nice enough to let us borrow the jury room, and Michael was able to do a real quick
I think
Facebook Live. I was arguing cause strike still, and he had to sneak out to do that. So that was interesting during this trial, but it was really nice for the judge to accommodate that.
Well, I had a good judge and I had a good partner who I absolutely could trust to do it without me there too.
Yeah.
So that trials are a lot easier when you have a good partner to try the case with. And so look forward to our next one.
Yeah.
Well, thank you guys for joining us. I look forward to having you next time on Trial Lawyer Nation. Thank you for joining us on Trial Lawyer Nation. I hope you enjoyed our show. If you're listening to this episode on a mobile device, please click on ratings and review and leave our show a 5-star rating and write a review. And if you're listening to this episode from our website, please leave a 5-star rating on the episode page. We'd love to reach more listeners, and doing this will help more attorneys find this podcast. You can also visit our website at www.triallawyernation.com to opt into our mailing list so you can stay updated on our new episodes. I promise we won't spam you. And thanks to your feedback, we've improved our podcast website. There's now a resources tab that you can click that shows you all the books we've mentioned on our podcast. If you have a Facebook account, please send us a request to join a private group called Trial Lawyer Nation Insider Circle. This exclusive group will allow you to hear about our guests before an episode airs, interact with the show, and get a sneak peek at some of the behind-the-scenes moments. I love to hear from all of you, and our Table Talk episodes are based solely on questions from our fans. So please continue to send us emails at podcast@triallawyernation.com. Thanks for tuning in, and I look forward to having you with us next time on Trial Lawyer Nation.
Each year, the law firm of Cowen, Rodriguez, Peacock pays millions of dollars in co-counsel fees to attorneys nationwide on trucking and company vehicle cases. If you have a case involving death or catastrophic injuries and would like to partner with our firm, please contact us. We have experience finding potential defendants that other firms miss, and we've added millions of dollars to cases by finding these sources of recovery. If you have a catastrophic injury or death case where the policy limits appear to be insufficient, give us a call. If we can find another defendant, we can partner on the case. And if we can't, then we won't ask for any of the fees. You can reach DeLisi Friday by calling 210-941-1301 or send an email to podcast@triallawyernation.com. She will coordinate a time for Michael Cowen to speak with you in person or by phone to discuss the case in detail. This podcast has been hosted by Michael Cowen and is not intended to, nor does it create the attorney-client privilege between our host, guest, or contributors and any listener for any reason. Content from the podcast is not to be